Hello. Thank you for tuning in to the second part of our podcast series, Leveraging the Law of Armed Conflict and Creating Human Rights Compliant Counterterrorism Policy. We will now pick up where we left off last time with Dr. Corey Zoli. I heard you talk about the IHL, or the International Humanitarian Law. How is that related to the International Human Rights Law? And are these laws applicable to the counterterrorism operations like we were talking about earlier?
Good. So as we were sort of developing, this kind of idea of developing what the more accurate nature of the terrorist challenge from a global perspective looks like, right, from an empirical perspective. As we were talking about that and then thinking about whether law of war norms or international humanitarian law norms actually cover this area, cover the nature of this challenge. So you can think about the Geneva Conventions, how the laws of war are kind of divided into two areas of law. The jus ad bellum, everybody sort of, their eyes glaze over when you start using the Latin, but there are sort of two components of the law of war, the jus ad bellum and the jus in bello. The jus in bello just means the rules in war, the rules of conduct during hostilities. The jus ad bellum just translates from the Latin into the rules for going to war. So how does a state justify going to war, especially in the post-World War II moment where essentially the charter outlawed war? It suggested that states could not engage in war freely as a part of their foreign policy or their national policies unless they had very good reasons of self-defense, reasons of being attacked, reasons of having some kind of UN Security Council authorization to manage a conflict situation. It was only under very limited circumstances that nation states were allowed, authorized under the whole new UN charter system to actually go to war. So in that context, those ad bellum rules, that justifiable reason to go to war, those rules have been, kind of covered in the Geneva Conventions and elsewhere. And alongside of that legal regime is the jus in bello, which is the rules that states have to use when they're engaged in conflict. Now, those conflict rules, again, are fairly familiar to most people. The idea that you can't target civilians. You have to make a hard distinction. It's called the principle of distinction. You have to make a hard distinction between civilians and combatants, and regularly constituted armies, if they're in a lawful, if they're in a war, if they're in an armed force situation, can only go after combatants. They can't target civilians. The idea that you can't use non-humane or non-humanitarian means to go after combatants. So you can't use exploding bullets. There are certain regulations around what kind of weapons can be used. The idea of military necessity, having to drive your decision-making in war. You can't just go and, bomb or blow up a whole neighborhood, right? It has to be a legitimate military target to even be a target in use of force situation. So there are these norms that are associated with the jus in bello. And lots of scholars and observers and practitioners have pointed out that many of those rules associated with the lawful conduct that states and their militaries can use in armed conflict, those don't really speak to the new conditions of asymmetric warfare. So they almost are as if they're rules from a different earlier era, which of course they are. And so many of the tactics that terrorist organizations use are not really covered by the jus in bello, by IHL. So terrorists, what defines terrorism? One of the ways in which we define terrorism is as a political or some kind of ideological movement in which civilians are targeted. So that's essentially how we define terrorism. It's the political targeting of non-combatants for some kind of ideological purpose, whether that's political purpose or religious-based purpose or some other kind of rationale. So that's by its very definition against IHL, right? You can't target civilians in a lawful warfare context according to the Geneva Conventions. And yet the very nature of terrorist organizations is precisely to target civilians, non-combatants first. So how exactly do you manage that situation under the laws of war? It's very difficult because the very behavior is antithetical to the rules, right? So that's where scholars have talked about multiple gaps in the Geneva Conventions and trying to manage new warfare situations, including terrorism. When it comes to terrorism policy, when law-abiding states, like the United States, like much of Western Europe and most of Europe and Canada and elsewhere and other places. I mean, when Israel, law-abiding state, when many states try to, develop rules to manage these kind of irregular, asymmetric conflict issues, it's hard to draw exclusively on the Geneva Conventions because the Geneva Conventions they are normatively useful, for covering asymmetric conflict, but they don't always, in their specifics, give help to states that are trying to manage these new kinds of actors. If we think about cyber actors who are potentially destroying infrastructure through their kind of use of cyber weapons, right, which are invisible. It's hard to figure out who the entity is, who's actually deploying the cyber weapon. It gets even worse, right, because the whole regime of the laws of war depends upon being able to identify who are the actors doing the act of force or act of war activities. So you can see where there's a kind of progression in the nature of war. Some people call it, postmodern war or fourth, generation warfare. There's a progression there, and the laws have struggled to keep up. So in the case of human rights law, many nations have said, well, IHL, humanitarian law, and human rights law, which are separate bodies of law. Human rights law is more modern in its codification. It's associated with the Universal Declaration of Human Rights, and then all of the core instruments after that, like the Convention Against Torture and other instruments. Many kind of progressive-minded, forward-thinking governments in modern democracies have said, we really need to make sure that IHL is compatible with human rights norms, even though they're separate regimes, even though human rights is not the regime that covers conflict and use of force situations. And actually in the United States, we make a kind of a firm distinction between this, whereas Europe, there's more attempts at compatibility and convergence between those two regimes. But in the United States, our approach to military actions and use of force actions and warfare has been to say, no, when we're actually in a conflict situation, when we're actually in a situation where our military is using force, we use IHL as our grounding special law. We don't use human rights as our grounding norms. We try to be compliant with human rights whenever we can, but we don't use it as our grounding norms. So there are some compatibilities. There are lots of compatibilities, but the regimes are actually different and interpreted differently by different nation states when it comes to managing new warfare, asymmetric warfare challenges. In the US, we've tried to suggest that any use of military force, this is like DoD doctrine, any use of military force has to abide by IHL, has to abide by the laws of war. That's our standard and commitment, and that's in excess of what the law requires, but that's our kind of humanitarian commitment. And we try to do that increased standard when it comes to human rights norms as well. But there are many situations where you can't abide by human rights norms in an actual warfare setting, and the humanitarian standard is actually the more applicable and more appropriate one there. Now, one other point to make about the importance of human rights compliance in warfare setting. When you have irregular conflicts, if you can show when you're trying to address those conflicts, when you're trying to combat bad actors or defeat actors who are targeting civilians or civilian property or civilian communities, if you can show that you respect IHL and human rights, it gives your side a legitimacy edge. It gives your side a clear indication to all of those who are caught up in these, kind of these civil wars or these, border skirmishes or whatever their regular setting is. It gives those people, especially the people who are non-combatants, it gives them a very clear picture that you're trying to actually resolve the conflict or help to resolve the conflict in a way that's law-abiding, that's norm-respecting, and that is designed to push for stability and a lawful environment post-stability. So it's always the kind of best standard if you can abide by both IHL and human rights norms, or if you can demonstrate that. But there are times where those sets of regimes conflict, especially given the nature of some of these asymmetric actors and their tactics.
Last question for you today, Corey. Why are so few people without a military background aware of any DoD initiative that involves military personnel anywhere in the world? And why are they not aware that it requires some sort of international humanitarian law, law of armed conflict, or law of war compliance? And why is this powerful regime of law one of the best kept secrets for conflict regulation? And how could a strategic communication plan possibly rectify this?
Yeah, those are really great questions. And in a way, I think one of you answered my question in one of your questions, the idea that the IHL, the law of war, is one of the kind of most powerful tools or best kept secrets in terms of international conflict regulation, in being able to regulate conflict, including asymmetric conflicts like terrorist activities and terrorist organizations. The norms are there, inside the law of war, inside IHL, the norms are already there. The idea that you have to make this radical distinction between combatants and civilians, which terrorists don't, right? The idea that you have to make sure that in a conflict setting that you don't resort to inhumane and unnecessarily brutal means, right? That you have to be humane in your use of force, right? The idea that a conflict, an armed conflict or a use of force or any instance of war, that changes when that occurs. That changes the rules about how adversaries, formal armies behave towards each other. There's a difference between peacetime and wartime. And in war, we need humanitarian norms, or otherwise things will get incredibly out of control. And it's taken humanity in a cross-cultural, trans-historical fashion, hard lessons over time to realize that those norms must be respected and they must be reciprocal in a war setting when we're on a war footing, because otherwise things get absolutely, out of hand and brutal, and you get the kinds of dynamics that happened in World War II, where all of a sudden you have a Holocaust, or you have 60 million people dead from a world war. You have world wars, right? And you can't prevent, at least in human history. Maybe in the future we can figure out some way to prevent war. And there are conflict resolution techniques that people can use. But so far, we don't have a way to eradicate or prevent war. And so while we have war, whether it's formal, interstate, formal armies on the conventional battlefield, or new forms of asymmetric warfare that may involve information operations or psychological operations or terrorist organizations, while we have these kinds of conflicts and use of force, you need humanitarian norms to be present and respected. Otherwise, the bloodshed increases and the cost to societies and communities increases. So that the fact that we actually have in our world this, set of norms that encapsulates all of that is incredibly powerful. It's a resource that is too rarely publicly discussed and deliberated and announced. It's amazing to me that unless you have a military background in the U.S. or unless you're a beneficiary being trained like in some other formal army, like if you're in the Romanian army or wherever, or the Australian army, right? Unless you're getting law of war training or the U.S. is assisting in your training, which happens many, many times. Like we have an enormous support structure for training other foreign armies in the law of war. Unless you have that kind of insider knowledge or experience, you really don't know about the law of war and how they apply. You might have heard about the Geneva Conventions, but you don't really understand how that's applied or applicable in conflict settings and use of force settings. And you very often don't know that it applies to irregular conflicts, whether it's cyber warfare or terrorist attacks.
Well, Corey, thank you for sharing one of the best kept secrets with us today. I'm hoping that all of your insight, will help other people that aren't in the military or that are, get caught up on international humanitarian law and, the law of armed conflict. And I appreciate you, doing this for HDIAC. I appreciate you taking your time out of your day. I know being a professor is super hard right now with everything going on. So I just wanted to thank you again.
You're welcome. And thanks so much for the questions. It was really great talking to you today.
Thank you for joining the HDIAC podcast series. To learn more about our other services, please reach out directly or visit us online at www.hdIAC.org.